I'm Vijaya in conversation with the immigration attorneys of the NPZ Law Group, serving immigrants and employers throughout the US, Canada, and around the world. And joining me is founder and managing attorney at NPZ Law, David Nachman. Namaste, David.
Namaste, Adab, Sat Sri Akal, and Kemcho to you, Vijaya, and to all our Radio Mirchi listeners.
Thank you, David. And I have a question for you, which is on most people's minds who are in the immigration race. So if my US immigration case is denied, does that mean it's the end of the road for me?
It's a great question, and one that we all get as lawyers here at the NPZ Law Group on a frequent basis. Vijaya, of course, before I get to that, I want to tell you what's hot, because we just found out that the H-1B lottery is going to be, they just announced it today. The H-1B lottery is going to be run from March 4th through March 19th, so 12 o'clock p.m. On March 4th will be the opening of the lottery, and it will be closing on March 19th at 12 o'clock. And that presumes that there are no glitches in the system. If there are glitches in the system, as they did last year, I believe they extended it a couple of days to allow for fairness, to allow everyone to get their, to get their registrations in. I also just want to remind our listeners that there are a couple of new issues to deal with on the H-1B front. One of them being this new $100,000 fee for individuals who are outside the United States. Number two, that there is a weighted lottery. It's not 100% random as it used to be, but now we have a salary, weighted salary issue. And of course, that the H-1Bs are keyed to the passport number. So even though you put in multiple registrations, you're only going to be chosen once. So all of these are some of the newer issues dealing with the H-1B. All of our NPZ Law Group lawyers stand ready, willing, and able to assist with H-1B registrations, and employers and prospective H-1B beneficiaries should feel free to reach out for any of us anytime. Now, with regard to your question, so I think the best answer to to everyone is don't give up the fight. We're in a very, very difficult immigration terrain. I know that I can speak for all the the excellent attorneys at the NPZ Law Group who do the good fight on a day-to-day basis. And when a denial comes in, and sometimes people think, oh, my case is denied, it's I can't ever get it approved. Well, that's not in fact the case. What we do is we take a step backwards. After we tell our clients to calm down and take a deep breath, we tell them that you can either refile the case, you can make a motion, or you can appeal the case. So there is recourse. And if an appeal is denied, a lot of people don't realize that there are several ways that they can also get action on their, on their cases. Of course, obviously, going to a federal court is it's a tremendous undertaking, and some of the considerations associated with going to the higher level have to do with timing. It has to do with the cost associated with taking a case to a federal court. Also, some strategic planning issues like the venue. Like, is it better to file a case in the Ninth Circuit, or is it better to file it in the Third Circuit? So, you have to look at, which federal court is going to afford better opportunities to get a case approved. We recently found out that the Ninth Circuit has declared Kazarian, the legal standard that applies to the EB-1 extraordinary ability case, that was deemed to be illegal by a federal court. That might, we don't know what the ultimate impact is going to be of that, but, that is certainly helpful and something that we can include in some of the documents that we submit. So there are a couple of things that can be done to challenge cases that have been denied in the federal court. There's something called mandamus.
Okay.
There's also something called the Administrative Procedures Act, Section 7061, which deals with challenges to agencies for unlawfully withholding or unreasonably delaying cases.
Mm-hmm.
You also have declaratory judgment actions, and we also have what's called habeas corpus. So these actions can be brought in the federal courts, and they can be used to challenge various determinations.
So there are options. Mm-hmm.
So there are options. And obviously we're, dealing with a little bit of an uphill battle because there was, and I don't mean to get too technical here, but there was a Supreme Court case that was called Chevron. It was called Chevron deference, where where basically deference was given to the administrative determinations of administrative agencies. So they would look to, the court would look to the decisions of the administrative agencies when interpreting, any type of, let's say, vague or an ambiguous language. Okay. Unfortunately, that was overturned in a case called Loper-Bright. But still, even with these decisions that are out there, again, the idea is that all of our listeners should know that they should not give up the fight. It's not easy. It's a difficult administrative, it's a difficult environment right now.
Yes.
For immigration, but we're in your corner, and we as NPZ lawyers are here to help fight for you.
Mm-hmm. That sounds excellent, and thank you for that, David. And of course, fighting the good fight for you in this immigration law maze and minefield, as it were, is the NPZ Law Group. Reach out to them today with any of your US and Canadian immigration matters. Their number is 201-670-0006, or simply visit visaserve.com and mention Mirchi for that special discount. And of course, it's that time of the show where I extend a big thank you to all of the attorneys. That's David Nachman, Samantha Oberstein, Lutka Zimovchek, Snehal Batra, and Gaganjot Mundra for making these complex US and Canadian immigration law issues so simple to understand. And of course, we are with you every other Wednesday, between 4 to 5 p.m. for more enlightening insights on immigration from the NPZ Law Group. So make sure you join us then. And for now, stay tuned to Mirchi. It's hot.